Welcome back to my channel. If this is your first time here, I'm glad you found this series. We explore the right of disposition, the legal right to decide what happens to your body after death, and how to make sure your wishes are honored every step of the way. This episode focuses on New Hampshire, a state that provides clear authority for those who take the time to document their decisions. In New Hampshire, you have the right to decide how your remains are handled through a durable power of attorney for health care or a written funeral planning document. This means you can appoint an agent, someone you trust, to manage your burial, cremation, or any other type of disposition. Once appointed, your agent's decisions take priority over everyone else's opinions. It doesn't matter what your family wants. What matters is your written instruction. Your documentation is your voice. It ensures your choices are carried out exactly as you intend. If you do not leave written instructions, New Hampshire law decides who has authority. Here's the order of priority. The person you appointed in your written directive or durable power of attorney. 2, your surviving spouse or civil union partner. 3, your surviving adult children, a majority if there's more than one. 4, your surviving parents or parents. 5, your surviving adult siblings, again, a majority. 6, your next of kin, following the order of intestate succession. 7, if no one qualifies or steps up, a public official or court-appointed representative will make the decision. Without documentation, your final arrangements could fall into the hands of someone you didn't choose. The law gives family members or authorized individuals 6 days after death to make burial, cremation, or other disposition arrangements. If no one acts within that period, or if there's a disagreement, responsibility transfers to the local public official or coroner. That 6-day window goes by very quickly. Planning in advance prevents confusion, conflict, and delays during an already emotional time. Family dynamics can be complicated. Maybe you're estranged, or you've chosen to go no contact. While your personal boundaries are valid, they don't automatically change the legal hierarchy. So unless you formally appointed someone else, the law still gives decision-making power to the next person in line, even if that's someone you haven't spoken to in years. The best way to protect your peace is to make sure your wishes are official. Put it in writing, sign it properly, and ensure your chosen person knows where to find it. Now, New Hampshire law does not specifically address chosen names or gender identity in matters of final disposition. So if you choose a chosen name or identity different from your legal documents, your written plan is essential. Clearly state your name, pronouns, and how you want to be represented. Give that directive to your appointed agent and make sure the funeral home receives a copy. Your words ensure you are honored as the person you truly are. So let's summarize the main points for New Hampshire. You can appoint an agent through a durable power of attorney or written directive. If you don't, the law follows a fixed order: spouse, children, parents, siblings, then next of kin. Families have 6 days to make arrangements before local officials can intervene. Estranged relatives may still have legal authority unless you reassigned it. Your written plan protects your identity, your wishes, and your peace of mind. As always, I want to thank you for watching. I hope this information helps you understand how New Hampshire handles the right of disposition and inspires you to take control of your own plans. If this video was helpful, share it with your family and friends. Many people have no idea how these laws work, and a simple conversation can save loved ones from confusion or conflict. Be sure to like, comment, and subscribe for more state-by-state guidance. And check out the rest of the Right of Disposition series, because every state has its own rules, timelines, and lessons to learn.